We have one case for argument this morning in the matter of the contest of general election held on November 4, 2008 for the purpose of electing a United States Senator from the state of Minnesota. Mr. Friedberg, I see you've reserved 10 minutes for rebuttal.
With the court's permission, Your Honor.
You may proceed when you're ready.
Good morning, and may it please this court. My name is Joe Friedberg. I represent the appellant. Let me begin by saying that Minnesota is quite different from many states. We have problems within our institutions, and when we do, we deal with them candidly and openly. We don't minimize them or sweep them under the rug to be discovered later by a federal court during 1983 litigation. That's why finding of fact 47 of the trial courts is so surprising. Announcing that we're proud of rejecting only 0.5% of our total ballots cast in November is misleading at best. The only ballots that get rejected are absentee ballots, and our officials rejected 4% of them. 12,000 citizens who made good faith efforts to vote were disenfranchised for a variety.
Did these 12,000 citizens comply with the absentee voter requirements?
Many of them did substantially, Your Honor. Many of them did.
Substantially, what does that mean?
Well, we define substantially as within the criteria adopted by the election judges in the counties across the state on election night.
Haven't we said in the past that the requirements, the statutory requirements, are mandatory?
They're mandatory.
With respect to the voters' conduct?
The law in this state has always been, Your Honor, that they are mandatory before the election and they become directory after the election. And the quotes from the cases for the last 75 years say that absent fraud and absent the lack of good faith, everything will be done to hold the vote valid. And that was said in Anderson and going back almost 100 years. So that when you look at a ballot, you look and determine whether or not it substantially complies. That is classic law in our state. It has never been changed.
Counsel?
Yes, Your Honor.
You said always. Fitzgerald versus Morlock, 1963. We seem to have made a distinction between election officials, where there is something that is outside of the control of the voter, and voters complying with the statute. And if I'm reading Fitzgerald right, that's a case in 1963, it says that the voters, it's mandatory, and they have to comply.
If I may quote from Fitzgerald against Morlock, Your Honor, it says, when a citizen makes a good faith attempt to vote, it will not be held invalid except by unequivocal mandate of the law or fraud.
But then the court goes on and it kind of bifurcates between an act of an election official and also is that then the act of the voter. And if I may quote from your own party's brief, in the reply brief, I think on the 16th of December, it talks about absentee voting being somewhat different in that it is a convenience afforded to the voters, and so far as the acts and duty of the voters are concerned, they must be held mandatory in all their substantial requirements. That's quoting from Bell versus Gamaway and also citing to Wichman.
Mandatory in all their substantial requirements, and the insubstantial ones are not mandatory, Your Honor, and it's the insubstantial ones that were relaxed in the metropolitan counties on election night, and it's the reason that there should be a fair distribution across this state. Every county should come very close to applying the same standards. This goes back to McEvan against Prince in 1914 and Erickson against Sammons. They always say, absent fraud, Let's get to the will of the voters. And these things which may look mandatory on the front end become directory on the back end if they don't go to the essence of the vote or fraud. And that's the way Minnesota has always been.
Counsel, as I understand the claims before us, we have a due process claim
We do.
and an equal protection claim,
We do, Your Honor.
amongst others. Do we have a claim before us that challenges the statute itself?
We do not. We did not challenge.
Do we have one that directly challenges the application of the statute outside of the due process and equal protection claims?
I'm not sure exactly what you mean there, Your Honor. We challenged the operation of the statute, its application. We did not challenge the basic statute on its face.
But only to the extent that there are due process violations
And
equal protection violations.
That is correct, Your Honor.
And the reason I ask that question is it seems to me that there may be, it's possible that there are statutory violations which do not rise to the level of a constitutional violation.
There may be, Your Honor, depending upon how you look at these statutes.
And my question is, are those claims in front of us?
Yes and no. When we began this case, we argued it as an equal protection case, and then ultimately after February 13th, we joined a due process argument. We took the position that the standards had to be pretty much the same countywide, and so we did that from the beginning. When the trial court determined that they were going to enforce a strict compliance statute on February 13th, we took the position that you have changed the criteria from election night. To use the vernacular, you've changed the rules after the game's been played. The judges were applying substantial compliance statewide.
Counsel, let me interrupt you. I'm interested in your due process argument, and at least as I read the federal cases, Griffin, Roe, Briscoe, it seems to me those cases are clearly distinguishable in the sense that in those cases there was an announced procedure before the election, and after the election officials changed the rules. Here we have a much different situation. We have a statute, and at least as I read these cases, I guess my question to you is, do you contend that the election officials engaged in widespread misconduct by announcing an election procedure before the election, that there was reliance by the voters and then a material change after the election?
No, Your Honor, but there was a material change after the election because the election officials applied classic Minnesota law, and then it's the trial court that changed the game afterwards and went back to...
So your argument, it seems to me, isn't that the election officials changed the rules, but you're saying that the panel violated due process by saying we're going to have a mandatory requirement. But how, at least under the federal cases, how do you get around the federal cases that rely on fraud, broad-gauged or widespread misconduct, in this case where we have findings that there's no evidence of fraud or misconduct? I mean, isn't there under normal standard of review, the question is whether those findings are clearly erroneous. And at least as I look at findings of fact 125 and I look at the conclusion of law 154, it seems to me that you have to show that that finding was clearly erroneous based on evidence in the record, and I'm wondering what that evidence is.
Your Honor, let me begin this way. Ordinarily, the findings of fact drive the conclusions of law. In this case, the conclusions of law came first and drove the findings of fact. When the trial court said, we're not going to look at what happened on election night, and excluded all evidence about what the election judges did on election night in relation to letting in ballots that they wouldn't let in.
Counsel, let me just stop. Where did the contest court so rule?
They ruled right from the beginning, Your Honor, and we answered it by submitting in an offer of proof hundreds of
I apologize
ballots.
for interrupting you, but when I say where, I mean where. Page citation in the record. And if you want to get that when you come back up in rebuttal,
I'll have to do that.
that would be
Your Honor.
fine. Thank you.
I'll have to do that. But they clearly excluded evidence of ballots that didn't meet their criteria set on February 13th from our evidence. We attempted to show that there was de facto substantial compliance, and it doesn't have to be de facto because that's the law anyway, but it was. We wanted to show, look at all these ballots that came in Minneapolis and Ramsey County and St. Louis County that don't even come close to comport to the standards that you've adopted going
Counsel,
forward.
let me, that ties to your offer of proof, which begins at least on the improperly accepted ballots at
Yes.
A589. And I know you're a trial lawyer, and in my experience, I've never seen an offer of proof like this that it doesn't identify witnesses, it doesn't identify what they're going to say in terms of what exhibit that they're challenging. And it seems to me that under the statute, under 209065, the rules of evidence, the rules of civil procedure apply. You know, why is this offer of proof not inadequate in that we don't have admissible evidence that can be considered by this court in determining whether you've met your burden?
Your Honor, I can even go further than that. In 43 years of trying cases, I've never heard of a written offer of proof. We set out to, when prior conduct was...
Counsel, have you ever heard of an offer of proof that's not on the record?
Not offhand.
The offer of proof is for purposes of appellate practice. So either you
Yes.
put it on the record orally, and there are some very articulate lawyers that put very good offers of proof on the record orally, or it can be in writing. So, I mean, I'm not sure that if you're going to make a distinction here, tell me what it is.
What I'm saying is we were going to do the ordinary thing, which is put the offers of proof in orally. And the determination was that take as much time as putting it in if they were going into evidence, and so the court suggested that we put them in writing.
I guess I don't have an issue, whether it was in writing or whether on the record, but I would like an answer to my question. It seems to me on paragraph 16, you say contestants would have offered the absentee ballot envelopes of a material number of voters in various jurisdictions, and then you reference representative samples of such ballots on C-1013. And it seems to me that a purpose of an offer of proof is to identify the name of the witness, the substance of the testimony, so that the opponent can come in and respond, if necessary, to that testimony. And here, it seems like you're offering little more than an opening statement of the in this case, Coleman's theory of the case, but no concrete evidence to back it up.
Your Honor, if you look at Appendix 709 in the next several hundred pages, you will see pictures of the absentee ballot envelopes that were open and counted in Minneapolis and in St. Louis County. We made that offer of proof because it was ruled irrelevant.
Well, Counsel, I'm going to get back and be very specific here now. Is that I am very bothered by your offer of proof. For example, you say you will obtain testimony from a substantial and material number of Minnesota county and election officials. You say you're prohibited from doing that. But in trial volume 26, you say is that you could have called all 87 auditors and all municipal election clerks, but we purposely didn't do that because we didn't want to take the time. Now, that implies to me is that you could have, there's no bar to it, you would have, but then let me talk about your list of sample ballots. I mean, as I looked at those, and I've gone through those, that's C1016, 1017, all of that, and they're basically just lists. And is that there are lists of names. And then is that you, in paragraph 4 of the March 2 offer, is that you said the testimony of a material number of individual voters, but no voters are identified. So, counsel, I'm really having a problem with what that offer of proof really says.
Your Honor, I can read from it. This is Coleman 646. It's Appendix 709 and the next several hundred pages. We do identify each and every ballot. The picture's there. Let me give you an example. This is the picture of a ballot envelope that was opened and counted in Minneapolis on election night. It makes its point. It's a voter, I don't want to use the last name, but it's the first one on 709, and it says, under where it's supposed to say witness, it says, note, I'm currently in Mount Juliet, Tennessee, and couldn't find a witness for Minnesota. That was opened and counted. That's part of our evidence. And then the hundreds of pages that follow, they are the actual ballot envelopes that were opened and counted in Minneapolis that blatantly violate the court's position on what the law is. And it was our position
Counsel, let us assume for the moment that those ballots which were counted on election night shouldn't have been counted because they don't comply with the standard the panel
we take
chose.
the position they should have been.
Well, if the panel's right on the law as to what should and shouldn't be counted, then they shouldn't have been counted.
All right.
And so we have presumably statutory violations on election night. How does that become a due process problem or an equal protection problem?
Well, it becomes an equal protection problem, Your Honor, when you realize, based on the evidence that we've shown and is in this offer of proof and testimony, that if people from around the state had all cast their ballots in Minneapolis or in Ramsey County, there'd be half as many rejected ballots. That's what the numbers show.
As I understand due process case law, the issue is whether there has been intentional and purposeful discrimination. And so, assuming that voters across the state have been treated differently, where is the intentional and purposeful discrimination?
Your Honor, I don't believe...
create the equal protection problem.
I believe in relation to equal protection, there is that law, but I do not believe it applies to voting issues. In relation to due process, I do not believe that that law is applicable.
Counsel, in the due process area, you rely on the case from Alabama.
Roe.
And what the court talks about there, and I think this is consistent with other due process cases as well, is voter reliance. The concern that the voter would have behaved differently had the voter known that the rules, as you say, were changed after the game was played. That seems to be sort of the driving principle. And I'm just wondering if you could articulate how that principle of voter reliance plays out in this case.
Your Honor, if I might respectfully disagree, I don't think that the reliance issue is the driving issue in Roe. In Roe against Alabama, the law in Alabama had been that you need 2 witnesses on each absentee ballot. When they got into a recount, and this was a very hot election for Chief Justice, and when they got into the recount, the circuit court started opening and counting ballots where there were no witnesses. They went over into the federal court and say, you can't do this. It's changed. It's not the same system anymore. And the federal court enjoined them, went to the 11th Circuit. The 11th Circuit certifies it back to Alabama. And the Alabama Supreme Court apparently reaches the wrong decision because when it comes back in Roe 2, the injunction remains permanent. But what happened there wasn't based on reliance. It was based, they did mention, there might have been some people who would have gone out and voted if they didn't have to get 2 witnesses. I don't think that's the driving force. And in this case, it would be ridiculous for me to argue that more people would have voted if they knew that in Minneapolis you didn't have to get a registered voter to witness it. I think that's just not worth arguing to anybody.
Well, counsel, but there are other courts that think differently. I take the Ninth Circuit. I'm looking at Gamza. I'm looking at Griffith, and I think it's the Ninth Circuit that summarized it. It says that in even looking at Griffin and Rowe, it says a general pattern emerged from all these cases taken together. Mere fraud or mistake will not render an election invalid. However, a court will strike down an election on substantive due process if two elements are present: likely reliance by voters on an established election procedure, as Justice Gilday is pointing out, and is that then you have significant disenfranchisement. It seems to me, you say that reliance by voters, but there are a number of courts, will you agree, that take a different position or appear to go in a different direction?
We have significant disenfranchisement, Your Honor. You're talking about a situation here where there's a geographical difference. Depending upon where you sleep, that depends upon whether your vote gets counted. Now, that's eminently correctable.
Well, counsel, again, assuming that the panel got it right on the law, don't we have a problem with not so much disenfranchisement, but allowing votes or ballots which should not have been counted on election night?
You have a horrible problem, Your Honor.
We have a kind of a dilution problem, don't we?
Well, it's worse than that, because dilution seems to indicate that you could do a proportionate reduction, which is just a fictitious remedy anyway. What you've got is the inability to say who got the most legally cast ballots if the count is full of thousands of, under the court's definition, illegally cast ballots. That's a terrible
But nobody's
dilemma.
challenged those ballots that were...
Are you speaking in the Bell sense, Your Honor?
It seems to me that we don't have an issue before us as to the ballots that were counted on election night being improperly included, so they should be now excluded.
Well, we are certainly not trying to get them excluded. But
that's my point.
We are trying to get them to be used as a control for what the proper evaluation of a ballot is. And that's only fair.
But that's a little bit of the cars in front of me were speeding. They got away. Why do I get the speeding ticket?
Well, they're not speeding, Your Honor. Those ballots that got in substantially comply with the law, and that's classic Minnesota law. The election officials in the metropolitan counties got it right. The election officials in the smaller counties got it wrong, and the trial court got it wrong. This is not a strict compliance state. It's a substantial compliance state.
Counsel, your claim is that the substantial majority of election judges allowed in ballots that satisfied a substantial compliance standard. Your position on brief and before the trial court is that most election judges, most ballots were allowed in based on a substantial compliance standard. The district court, the panel here said you had not sustained your burden of proof, essentially, on that question, that there were some isolated proofs, but that it was not this far-ranging practice that you alleged before the court. How are we to say that the court here, the panel here, abused its discretion in making that conclusion?
Your Honor, we didn't say most did that, but I don't think we said most. I said if you add up an amalgam of the election judges from around the state, you're going to find an overall substantial compliance situation. And then the court said, what you want to show us about what was done on election night is irrelevant. And we
Well,
said,
I'm quoting from your brief, page 39, footnote 15. Quote, "The overwhelming majority of Minnesota's counties and cities applied various presumptions," meaning
yes,
they didn't strictly comply with the statute. They applied these various presumptions.
yes.
And I'm just troubled by that very broad statement, that the overwhelming majority of Minnesota, I mean, where in the record is there evidentiary support for your assertion?
You can read the complete testimony of Mr. Mansky from Ramsey County, the biggest political subdivision. He says, no application, our fault, we let it in. Unsigned.
I understand you have evidence from Ramsey County, but where is evidence from the overwhelming majority of the counties and cities?
Every auditor we called, as I recall, made exceptions. Now, I think we only called about 26 or 27. And
Well, we have 87 counties, and I mean, we are reviewing the work of a panel of 3 trial court judges here, and they took evidence. And where is the evidence even that you called, as you said, you didn't even call witnesses from a majority of Minnesota's counties? You're asking us to presume, based on the testimony from a sampling of counties, that practice is applied to the majority of the counties.
Your Honor, the evidence here, even from the Secretary of State, is, for instance, the counties didn't check to see if the witnesses were registered. That's the evidence in the case. There's only 6 or 7 that did, resulting in thousands of ballots presumptively, and this is a common sense presumption, because you've got 180 people kicked out in Little Carver County because the witness isn't registered, and you have none in Minneapolis and none in St. Louis County, you can presume the people in each county are as smart as each other. So all you have to do is extrapolate, and I hesitate to use this case for anything, but they did that in Bush against Gore when they compared the relaxed standard in Broward County with the unrelaxed standard in Palm Beach County, and said the population should have equaled. When Plymouth kicks out 75 for signature mismatching and 31 counties in the state kick out none, we've made our case. You can't make it any better than that.
Counsel, your time has expired on...
Before, I'd like to frame a question so I get it answered on rebuttal, if I may. Counsel, I'm still having problem with your saying that we're a substantial compliance state. And I mean, as loud as you speak on this issue, there's language that I don't think you can overcome. And it's Wickelman and Bell, but I'll give language again from Wickelman. It says is that if the statute were a directory, the argument would be of some force. But it has no application here because the statute is mandatory. And then the court goes on to express concern about letting the bars down altogether because of fraud. And then it says the absentee vote statute is in derogation of the general election law. It's different from the common law election law and should be strictly construed. So when you come back, I got to deal with this language, and is it? I mean, it's in Bell, it's in Wickelman. I can find another place.
You want me to deal with it on a rebuttal?
Yes, please do.
Thank you, counsel. You may proceed.
Thank you. May it please the court. My name is Mark Elias, and I am here on behalf of Al Franken. I would like, if I might, to start by noting one of the most significant findings of fact made by the trial court.
Counsel, before you get to that finding of fact, let me ask a question, and hopefully counsel for the other side will be able to respond to this on rebuttal. To the extent that the United States Senate will make the ultimate decision here, and to the extent that they don't have to follow what we do, how do we issue an opinion and without having it be an advisory opinion? In essence, do we have authority to do anything here?
Your Honor, this question was raised with the district court as to whether or not the court had jurisdiction. The court found, and we believe appropriately so, that the court had jurisdiction to determine who received the most lawful votes, even though the Senate has within its jurisdiction to decide who is seated. That is indeed the holding of a case from South Dakota that involves now Senator Daschle, but then Congressman Daschle's first election. And it is a distinction that in Roudebush, the Supreme Court adopted, albeit under slightly different circumstances, that the ability of the state process to move forward, so long as it does not impede the Senate, does not deprive the state court of jurisdiction. So I believe the court has jurisdiction to proceed. It is no secret, obviously, that I stood here once before suggesting that a certificate of election should issue so that the Senate business could proceed in the interim, but the court spoke loud and clearly on that point. But I don't think that there was a suggestion in that opinion that there was a complete lack of jurisdiction. I think that such a finding would have been inconsistent, candidly, with the court's ruling in the Franken v. Palenti case.
Can I just move to the question here is, who got the most legally cast votes? And what I want to know really is your position on the merits of paragraph 16 of contestants' offer of proof. In that offer of proof, that's the one Justice Dietzen referenced during his questioning. In that offer of proof, and specifically Exhibit C-1013, I mean, you look at the first ballot in there, the first envelope in there, and it appears facially that that was not a proper absentee ballot. And what I want to know is, if we're supposed to decide who got the most legally cast votes, and there's evidence that suggests that illegally cast ballots were accepted. Now, I understand we can't tell who they voted for, because that horse is well out of the barn. But how can we tell who got the most legally cast votes?
Well, Your Honor, this is part of the problem and frustration, candidly, with appellant's case. We have a ballot envelope. We have a copy. We know that that voter voted. We don't know if the voter got a different ballot. We don't know if there was a Uokava situation involved. We don't know what the facts and circumstances are other than a copy of an envelope. And there is perhaps no fact that was more clearly established by more witnesses being asked the question and testifying directly than a phrase that was used by one of the first witnesses from the Secretary of State's office, which is that every ballot tells a story. That was a phrase that resonated through this very courtroom day after day, witness after witness, that you cannot do, as appellants tried to do in the trial court below and are trying to do before this court, to take broad brushes and say, here are categories of ballots, because as many ways as there are to cast a ballot, there are ways for ballots to be rejected for noncompliance with the law and to be corrected when diligent local officials contacted voters, reached out to voters, looked into the facts and circumstances behind the voters. So candidly, being offered a written offer of proof, the first of which came the day that the...
Forget the procedural niceties. I mean, your point, I think, and correct me if I'm wrong, your point is, look, it was his burden to prove it. He didn't prove it. He can't stand up here now and speculate.
That is correct, Your Honor. That is correct. And if I might, the finding of fact that I wish to call to this court's attention, which goes to this point, is from the March 31st order of the trial court, in which they held that of all of the rejected absentee ballots at issue in this case, the parties proved registration for approximately 650. 650 of all of the ballots presented to this court. That's voter registration. That's not all of the other requirements that appellants now have complaints about, but this is the most fundamental requirement, that the voter be registered. Of those 650, 351 were opened and counted. So the universe of ballots properly pled, and about which this trial took place, stands at 299. Now, obviously, the margin separating the two candidates is 312. As a result, even if every one of those 300 or so ballots for which voter registration was proved, doesn't mean the witness was registered, doesn't mean that the certificate was properly completed, it doesn't mean that they only cast one ballot, but they were at least registered. Even if all 300 of those were for the appellant, and even if all 300 met all of the other requirements, it would still be impossible for the appellant to make up the difference. And since the jurisdiction of the trial court and the jurisdiction of this court is to determine who received the most lawfully cast ballots, the question answers itself. Al Franken received more lawfully cast ballots on Election Day than did Senator Coleman.
Counsel, were any illegally cast absentee ballots counted and included in the vote total?
I will answer that two ways. One is to say that there is nothing in the record identifying a specific ballot that was in the vote totals. I think it is fair to say that in every election, in every state, in every county, in every precinct, there is some ballot somewhere where a felon voted and it wasn't picked up, and where someone wasn't registered and skirted around the table, where some other irregularity took place and it wasn't caught. But that has never been the standard in this state or anywhere.
Well, let me phrase it this way, is that, I mean, we're talking here about the universe of Minnesota absentee ballots. You would have us, you've got a broad lens. You look at the whole universe, you say there is some intelligent design mandated by statute, and there is not chaos. It is order. There may be some, and you concede, some aberrant star systems or galaxies, however you want to do it. Now, what Mr. Coleman is saying is that he focuses on, look at this aberrant galaxy. Look at this aberrant system. This is proof that the universe is chaos. And in fact is that they've shown me that. They've shown that there's some chaos in this universe. Now it's been pinpointed. Tell me why they have not shown us enough that we should not implicate due process and equal protection here, because is that, we can't see the whole universe, but they've shown us enough to show there's a problem, and it implicates due process and equal protection.
Your Honor, I have several answers to that. The first is the trial court, reading this court's decision in Bell, correctly noted that the time to challenge an unlawful vote is before it is separated from its envelope. It is at the time that the ballot is delivered to the precinct. And
but counsel, the problem I have with that is many of these were counted by absentee ballot boards in the metro area, and I don't see anything in the statute that would provide an opportunity for Coleman to challenge at that absentee ballot board without, and I certainly don't see any indication that he would have received notice, or either candidate would have received notice. So it seems to me we have those categories that would have been on that outside envelope that there was no opportunity for Coleman to object to, and we're now left with what's on the return envelope at the precinct, for which he could have, I suppose, under the statute, objected to, just like an in-person ballot.
I think
am I correct?
I think Your Honor answered the question in the last statement, which is that ultimately he could have objected to those at the precinct, and though it may have been difficult to do so
but there are, counsel, some that would have been on the outside envelope that was not part of what went to the precinct that he would have lost the opportunity to object to, right?
I believe that the outside envelope goes to the precinct along with the ballot. I believe they're separated at the precinct. The outside envelope is reviewed for determination of whether it's accepted or rejected at the absentee ballot board, but I believe...
Okay, well, setting that issue aside, we're now at the precinct and we have the return envelope. What innocent explanation, if any, is there for these ballots in C-1013 that don't have the voter's signature? I mean, it seems to me that that is a clear requirement and on its face clearly not complied with. So, I mean, is there an innocent explanation? I'd like to hear it.
Your Honor, there may have been a replacement ballot. We don't know. We stand here being told that there are, quote, some 4,400 ballots. Some 4,400 ballots. That some subset of some 4,400 ballots. This court ought to go back and take an amalgam, a word used in the brief and used again today at argument, an amalgam of practices through 87 counties. After the election's concluded, the court ought to set the standard based on what the amalgam of practices was, and to determine which of the some 4,400 ballots that were presumably cherry-picked by counsel and by the appellant to meet their other needs, and figure out which within that universe of 4,400.
Counsel, what's the answer to my question? Is the lack of a voter signature a voter signature is a statutory requirement.
It is indeed.
Absent that,
it is indeed, Your Honor.
Improperly accepted ballot, isn't it?
It is indeed, Your Honor, but again, we don't know the story behind that ballot. And in this courtroom, we heard...
Then what would be an innocent explanation for why that would occur?
That there was a replacement ballot. That the individual was unable to sign their name because they were handicapped and unable to write. That I don't know what the other reasons are, but there are stories behind these ballots. There are reasons why the election officials accepted and rejected ballots, and simply appending them to a document on the last day of trial and delivering them to us is not evidence. It's argument. And Your Honor, I specifically point this court to the finding to the court's ruling that this argument was waived for failing to properly plead it and failing to properly identify these ballots as in response to discovery requests. These exact questions that Your Honor correctly asked today are questions we asked before trial. Tell us which ballots they are so that we can go out and prepare for trial.
Counsel, let me just explore that with you for just a minute. I certainly see findings from the panel that there weren't an answer to an interrogatory. But going to the statute, a notice of contest has to set forth grounds. It doesn't say that a pleading has to contain legal theories like due process, equal protection, and it certainly doesn't say that in an answer you have to plead all affirmative defenses, and certainly here you didn't plead waiver. So if we follow your waiver argument, you didn't plead waiver, so you waived the right to plead waiver.
Your Honor, our concern was not the failure to plead due process, failure to plead equal protection. It was a failure to identify the ballots. Which ballots? Don't tell us there are some 4,400. Which are the ballots? So that we can do what we need to do to prepare for trial, which is to go out and look at those ballots and find out the answers to the very questions that Your Honor asked me. What is the story behind this ballot? If every ballot tells a story, what's the story behind this ballot? And we asked that question before trial began and never received an answer. And it was not until the close of the case that the ballots were identified. And at that point, it was obviously too late. The waiver that I believe Your Honor refers to regarding the pleading of a cause was the due process claim, where equal protection was pled. And during oral argument, I sat in this courtroom and for the first time heard Roe versus Alabama, a case which I am quite familiar with, uttered as part of the closing argument. Now, whatever notice is required of a claim of a due process violation, it clearly must come before the contestants close their case in argument.
Counsel, let me switch subjects here a little bit. The equal protection and due process claims, what standard do we look to in reviewing those claims?
Well, I believe Your Honor correctly identified that if you look at both the federal constitutional law and the state constitutional law, that absent a case that involves a burden on a suspect classification, which is kind of a separate type of equal protection or due process claim, and there is no allegation in this case that we have a burden or either intentional discrimination or a burden on suspect classifications. That absent intentional or purposeful discrimination or arbitrary treatment that is so extraordinary that it undermines the fundamental fairness, then there is no violation of equal protection.
Counsel, that isn't the standard that we applied in Erlinson, though.
I believe, Your Honor, in Erlinson, the court noted the holding of Bell and Wickelman noted the Supreme Court's standard in McDonald of rational basis scrutiny, and adopted something, it appears to me in my reading, akin to either arbitrary and capricious or rational basis. So it was a low level of scrutiny. Whether you look at Erlinson or, frankly, whether you look at Timmons or Burdick, which are the sort of more sliding scale approaches, the administration of elections, which is really what we're talking about, receives the highest deference by a court. The states must be able to write laws about how ballots are going to be sent out, how they're going to be received, how they're going to be processed, and how they're going to be counted. If you hold that up to heightened scrutiny, then you will put sand in the gears of allowing an election to take place.
But you would concede that changing the rules after the election
Yes.
is a violation of fundamental fairness.
Indeed, Your Honor. And indeed, the changing of the rules would be to say, let's hold an election, then let's figure out what all the counties did, create an amalgam of that, and then apply that standard to the past election. The clearest way to avoid a problem under the Due Process Clause and under the case law of Roe v. Alabama and Briscoe and Griffin is to have the court enforce the law as it's written. And this court has made crystal clear through a series of cases that when it comes to absentee, the requirements for absentee voting, there is mandatory requirement with the voter's responsibility to comply with those provisions, and the clearest way to avoid it.
Counsel, now I want your cites to that and the law, because that's a question I asked contestants to address on rebuttal. So when you cite that, I mean, just what is your authority that it is mandatory, and in fact the change would be to do a substantial compliance instead of strict compliance?
Well, Your Honor, I would point you to Wickelman v. City of Glencoe, in which this court said, and I quote, "The provisions of election laws requiring acts to be done and imposing obligations upon the elector which are personal to him are mandatory. He is personally at fault if he violates them. If his vote is rejected for such violations, it's because of his own fault, not that of the election officials. Such provisions prescribe mandatory conditions precedent to the right of voting." This court was clear in Wickelman. I could also point you to Bell, where they quote extensively from Wickelman and add additional emphasis to it. But I don't believe there is any doubt with respect to absentee voting as to the mandatory nature of the requirements on the voter. And with respect to the second part of your Honor's question, the due process prong of this, if you look at the facts of Roe, you are struck that Roe stands for the proposition that a statute that requires proper witnessing for absentee ballots cannot be lowered by the state court after the election has taken place. So if this court is concerned about a potential Roe violation, the easiest way to avoid that is to simply apply the statute as the trial court did, as it is written, not as it might be better written by the legislature, not as it might be rewritten by the legislature. I would add an observation along these lines, Your Honor. Minnesota is one of a handful of states. I practice in election law throughout the country, and Minnesota is remarkable for the lowering of the barriers that have taken place to allow in-person voting. It is one of the most friendly and progressive states when it comes to in-person voting, and that was a legislative judgment that this state made. And every time it made that judgment, it could have said, you know what, we're going to follow the lead of Oregon, we're going to follow the lead of Washington, and we're going to make vote by mail easy. We're going to make absentee voting easy. And they chose not to do so. And that was a conscious choice that if you look at the Crawford decision from the US Supreme Court, where they upheld an Indiana statute involving ID, they identified the legitimate interest that a state has to prevent fraud and cited specifically.
Can I just go back to Erlinson for a minute? I mean, we said there at page 732, by treating similarly situated voters differently with no rational explanation, the statute violates equal protection guarantees. And so that's the argument that's made here, is that similarly situated absentee voters are being treated differently. And you would articulate the rational explanation for that different treatment as what?
As the need for the counties and the precincts to have the flexibility to allow elections to work. The fact is, in Pine County, where there may be one street called Main, in Minneapolis, there may be 20 streets that have Main. So in Minneapolis, you may need a different standard for whether or not it says Main Street, Main Avenue, Main Boulevard, whether it has a directional
Is there evidence in the record to support this rational explanation that you're offering now?
There is indeed. The trial court found specifically that differences in technology, that differences in personnel and resources were among the differences that justified the different interpretation that counties brought and personnel brought to being satisfied. And I point this court to that operative word. If you read the statute, what it says is that the election judge must be satisfied that these requirements are met. And that term satisfied obviously connotes that there is going to be some measure of discretion involved, some reasonable discretion that puts the grease in the joint, so to speak, that lets the election take place on one day at the same time that the election judges have to keep the lines from getting too long, the polls opened on time, keep disruptions from happening, make sure new voters are getting registered, make sure that people are getting orderly through the equipment. They also have to be processing these ballots.
That sounds like substantial compliance, which is, of course, exactly the opposite of what you're arguing.
Your Honor, it is not substantial compliance. The requirements are mandatory in all respects. The fact that a county official, an election judge, one Democrat and one Republican working together, might use different pieces of evidence to meet their need to be satisfied doesn't mean the law isn't the same everywhere. The requirement that a witness be registered, for example, a point that appellants make much of, that is the law in all 87 counties. In different counties, there are going to be different practical considerations to how the election judge satisfies themselves that they are registered. In some counties, they're going to satisfy themselves by looking up in the SVRS terminal. In some counties, that's either not available to them because they don't have the technology available, or because it would just simply be impracticable. So they rely on other indicia, like the address put down by the witness. That doesn't connote a different standard, and it certainly doesn't rise to the level of an equal protection violation, or anything that this court has ever held would cause doubt on an election. And in that regard, I would point, Your Honors, to the court's discussion in Green, contrasting cases like Clayton v. Prince and Berg v. Veed, and subsequent to that, Hahn v. Graham, with the facts and the holding of Vetch. And I apologize if I've mispronounced the name of that case. In Vetch, Green says, this court found, quote, the officials in charge of the election committed such serious and numerous violations as to indicate not only an utter unawareness or disregard of election laws, but also such a striking absence of effort to comply with any laws that no confidence could be placed in the integrity of the election. That is because the court said, quote, an absence of all effort to comply with the law is the equivalent of bad faith. And if you look at the history of the cases in this state, the garden variety differences between counties, or the garden variety problems that crop up in every election, do not lead to a constitutional or statutory problem. It is only where you have this complete failure, this complete absence of any standards, this complete absence of any effort on the part of the election officials to comply with the law, that this court has held that there is a cognizable injury in a contest. And that squares completely with the holding of the US Supreme Court in Bush versus Gore, where again, the Supreme Court said it was a standardless recount. It was a standardless recount that took place under the auspices of a court, where a court could have imposed standards and simply turned a blind eye to the standards, so that you had some counties doing partial recounts and some counties doing full recounts and some counties counting ballots one way and some counting ballots another way. There is nothing in the record of this case and nothing in the trial court's findings in this case that would suggest that level of problem.
Counsel, you bring up Bush versus Gore, and you've talked about some long-standing principles that apply in equal protection. Why aren't those long-standing principles about intentional discrimination go by the wayside in light of Bush versus Gore? And is it Bush versus Gore, at least with respect to election law, puts in place a different standard and those long-standing principles don't apply anymore?
I think what Bush versus Gore says is that you can have conduct that becomes so arbitrary, that is so egregious that it essentially rises to the level of intentional. And I think what the court found in Bush, and it's the reason why, though we have not argued, as others have and many in the future will, that Bush versus Gore was a one and done case, no precedential value. I think it's fair to read Bush that though it has precedential value, the court was clear in limiting it to a really unique set of circumstances where you have conduct, where you have a court overseeing a recount. And let's remember, in that recount, these ballots in this recount were open. Governor Bush's team knew what the score was, and Vice President Gore's team knew what the score was. The veil of ignorance about what was in these ballots had been lifted at that point, and they were looking at completed ballots. And without any standard in that circumstance, with a court standing by and letting these ballots be counted by whatever standard the election officials came up, you had an extreme example of where gamesmanship by the two sides could take place. Because they knew if they ruled that the standard applied in a certain way with a certain ballot, they knew what the outcome would be, because they in fact had the ballot in front of them. It was opened. None of that was present on Election Day in Minnesota. In Minnesota, you had hardworking, and the trial court found this and found it clear, and it was the testimony of every witness. You had hardworking Minnesotans who went and did everything they possibly could to administer a fair election. And yes, they used the different tools available to them in the different jurisdictions to make that work. But that's not a violation of equal protection or due process.
Counsel, your time has expired. Thank you.
I believe I have some direct questions to answer. Just Gilday, on page 4 of our brief, it says, after several days of such testimony, the court ruled any disparate treatment of ballots on Election Day was irrelevant. It therefore refused to permit evidence regarding how local officials judged absentee ballots on Election Day. And there's about 10 citations there to the transcript where I repeatedly tried to get that evidence in and repeatedly could not. It also refused to admit evidence absentee ballots on Election Day that failed to meet strict compliance standards, and we give you 5 transcript citations there. I couldn't get it in, and I tried to the point where I strained the court's patience. I didn't want to go any further than that. These judges were very well-tempered.
But counsel, let me just explore that with you. I'm still hung up on this offer of proof C-1013, and I guess, let me put it this way. Is it your contention that all you need to show is that there is a ballot that doesn't have, for example, a signature on it to prove up that it was improperly accepted by an election official? Or do you concede rather that you have to show that that it was otherwise improperly accepted? And I guess what I'm getting at is there could be other explanations, and as Franken's lawyer argues, every ballot tells a story. So we don't have the story, so how do we judge?
First of all, Your Honor, that might be the biggest non sequitur in the history of Anglo-American jurisprudence. But every ballot doesn't tell a story. Whether a ballot should be open and counted, you do that from the face of the ballot. That's how the judges made the decision on election night. That's how the judges should have made the decision in the trial court.
Okay, well, beyond that, do you concede that there's other reasons that it was a ballot that doesn't have the signature on it was properly accepted?
There might be an explanation for that. Neither of us know, but there might be. That's true.
Counsel gave one explanation. The other explanation is we, for the first time in Minnesota, have 292,000 people. There's long lines going to City Hall getting these applications for absentee ballot, and I'm only imagining, but is there at least some evidence in the record that you have the clerk behind the counter that's accepting the ballot at that time? And is there at least the possibility that the clerk inadvertently failed to get that ballot signed by the voter before it was accepted?
Those things are all possible, Your Honor, but when you look at Appendix 709 forward, we're talking about hundreds of ballots, and we put a sprinkling in of hundreds from just Minneapolis and St. Louis County. And statistically, sure, there might be an official error here, or there might be a replacement ballot there, but we're talking about hundreds. And when we talk about the difference between Carver County...
Counselor, but a sprinkling doesn't help us, does it?
Oh, I think it does, Your Honor. We extrapolate in life. You take Carver County, where there's 180 ballots kicked out for non-registration because they checked non-registration of the witness. Then go over into Minneapolis and St. Louis County, where they kick out none. Can't we say that it's reasonable to believe, one county being smart as the other, that you're going to find approximately the same percentage? And so you multiply it times 4 or 5. Now you know that in all likelihood, more likely than not, which is our burden, there are 1,000 of them.
I would suspect that the other side would say, bring in the ballots and let's look and see.
But there's no reason to, because our burden of proof is to make it more likely than not prove it so that nobody has any doubt.
I think that their argument would be that we need to see the ballots so we can show what happened and why it was either properly or improperly
they grabbed onto
rejected.
Excuse me. They grabbed onto this statement by Mr. Gelman that every ballot has a story.
I'm not interested in the story of the ballots, but one would like to know whether they were properly or improperly accepted or rejected. And the only way to do that, presumably, is to look at specific ballots.
Well, they're in our offer of proof, and the trial court didn't look at them. There's no indication anywhere that any of these hundreds of ballots were ever looked at by the trial court.
Counsel, let me ask you this question. In the during the recount proceedings, there was a motion for the injunction of your client. And on page 9 of that motion, there is this statement: the canvassing board must strictly follow the legislatively imposed requirements for voting by absentee ballot in order to preserve the integrity of the entire election. Is that consistent with the argument you make here today?
No, it's not consistent. But, Your Honor, you're going back to a time when we believed that the election judges uniformly applied the law and that they applied it the way it was written. It's later, and if you remember, we tried to get in another 500 or 600 of those when we realized the discrepancy between the geography. When we realized that whether your vote counted depended upon where you cast it, then we changed and we said, you gotta enfranchise these people. You can't take away their vote because of where they live. And we changed when we realized that the standards were different around the state.
How do we enfranchise people who didn't comply with the law?
But they did if you apply the same standards that the election judges applied on election night, which we maintain, and I have to get to Judge Anderson's question, we maintain is a substantial compliance standard. That's what they did.
I suppose in the end we will decide what the law means and what the law requires.
I'm sure.
But if we conclude that its terms are mandatory, then how do we enfranchise all these people who didn't comply with the mandatory terms, assuming that they didn't?
If you determine that the trial court's standard is correct, then it's a different standard than was applied on election night, and you have a due process violation.
And what was the expectation of the voter? What would have been the expectation of the voter when they cast their ballots? Would they have the expectation of compliance with whatever they did on election night, or would they have the expectation of complying with the statute?
Your Honor, all I can tell you is that every voter here, the 12,000, forget the 4,400, every one of them did the best job they could do to get their votes counted, which brings up the issue that the ones that were rejected don't know about it, and I don't know how we apologize to them for that.
Counsel, I'm going to pause here and just ask, is there any evidence of any fraud, any favoritism, or anything other than that the elections officials here in Minnesota tried to do the best job possible and apply the law?
Absolutely not. Absolutely not. And there's no voter fraud. There's no election fraud. The problem was that, if you go back to Erlandson, when they talk about is this a right or a privilege, and the court didn't resolve that question. What's happening now is there's a great motion in this country, in this state, to vote absentee. 10% of our voters voted absentee this time. People are voting absentee. It's no longer a privilege. The court didn't resolve it in Erlandson, but the majority opinion quoted Mr. Justice Marshall in Skinner against O'Brien when he said, this situation in Skinner against O'Brien is a question about whether they can vote at all, not whether it's a privilege to vote absentee. And that's what it's become in this state. Next time we're liable to have 20.
Yeah, but
Isn't that something
counsel,
for the legislature to fix, not this court?
And isn't the legislature have a right to be concerned about fraud?
It does.
And put in a strict standard? So don't we defer to the legislature decides it's a strict standard? And with good reason, to prevent fraud, because it is an area where fraud can occur. And the cases are replete where fraud has happened with absentee ballots.
As a matter of fact, Your Honor, if you go back again to McEvan against Prince, and Erickson against Sammons, and Fitzgerald against Morlock, and Anderson against Rolvog, those cases all say that when a person makes a good faith attempt to vote, absent fraud, substantial compliance is enough. Absent fraud. There's no evidence of fraud in this election. And maybe it's the law out there. Maybe it's the character of the people in Minnesota. We don't have any fraud. I do have two fraud cases in answer to your question, and they're both Wickelman and Bell. They're both fraud cases. That's why they don't count.
Chief, can I ask a question?
You may.
Counsel, do you concede that under MnStat 204C13 subdivision 6 that a candidate has the right to challenge ballots at the precinct, and at least with respect to this statute, the return envelope would be cast at the precinct, and therefore the candidate would have the right to challenge that return envelope at the precinct under that statute?
Absolutely, 100% unequivocally no, Your Honor.
Does that statute give the candidate the right to challenge an in-person ballot at the precinct?
It does.
And so your view is that subdivision 6 is limited to in-person and not absentee balloting, even though both are in the language of the statute?
Maybe theoretically, Your Honor, but the testimony in this case from Mr. Mansky, Ms. Reichert, Mr. Gelbman, and Mr. Posner, all the people asked, I asked a question, do challengers have anything to do with absentee ballot in these times? And the answer every time was absolutely not. Bell has no application. Based on what's done today, it's an anachronism. And Bell was a fraud case in a one vote, one precinct thing anyway. So all the evidence, including the instructions from the Attorney General to the election judges, no relationship between challenges to ballots and absentee ballots. Cannot be done. It's not physically possible. They're there to challenge the eligibility of an in-person voter.
Counsel, your time has expired.
Thank you, Your Honor.
We shall take this matter under advisement, and an opinion will be forthcoming. We are adjourned.